Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. One of the things that's true in every trial is that both sides are going to get rulings that go the other way. There is a ruling to suppress evidence. The state doesn't like it, they object. There is a ruling to admit evidence. The defendant says, hey, wait, you can't do that. And they argue about it. And eventually, the judge makes a ruling. And when that ruling is made and he doesn't reconsider it, as a lawyer, you have to let it go. You make the record. After you have a discussion with the judge, for example, let's say that there is a question about whether or not the question you have asked is appropriate, that there's sufficient foundation for it. And you tell the judge that there is because of something that was said in the trial. And then the judge says, well, that's not what I heard, and I've overruled your motion, we're going on. At that point, what you have to do, politely, is ask to make a record. And in most cases, the judge will let you make a record. If he doesn't let you make a record, then you say, very well, Your Honor, the record will reflect that you are not allowing me to make a record in this issue. And then you sit down, shut up, and don't raise the issue again until the appeal. Because otherwise, what you do is you draw, in some cases, professional discipline for not obeying the orders of the tribunal. And you also violate rule number 1 of trial work, which is don't honk off the judge. Yesterday in the YSL trial, the issue of whether or not some testimony and some statements should be admitted against the conspirators was essentially discussed and rediscussed between the prosecution, the defense attorneys, and the judge. Now, love him or hate him, the judge is doing a good job in this case. He is applying all the correct analytical procedures to reach the results that he's reaching. And you can disagree with whether he's made the right call or not, but you really can't disagree with the fact that he's taking the time to do what needs to be done. And so this is how this issue originally comes up. We're going to start with his ruling on a motion.
Out, Your Honor. He did it. There's a total of 28 times where he does something like that. Literally, he says, do you remember explaining that what you were referring to is at the hospital, that the police were telling us to lie, put thug in it, when you talked to Detective Lewis?
Okay, but that's...
So when he says, do you remember a thing that there's no evidence took place, he is asserting that, one, it took place, and then asking the witness improperly in front of the jury.
Did he ever talk to Detective Lewis?
No, that's just what I'm telling you, Your Honor. And then Mr. Steele gets here and says to you all this stuff and still never shows you anything to suggest that Adrian Bean talked to Detective Lewis.
Okay.
The state's objection here is to foundation. Foundation, as we've talked about before, is you have to establish that how somebody knows something before you can get into what they know. In other words, you can't just say, the blue car ran the red light, didn't it? You have to say, you were standing on the corner, right? It was 3 o'clock in the afternoon, right? Yes. And right about that time, two cars entered the intersection. Yes. Blue car and the red car. Yes. What did you see? Now you've got foundation and you can establish what you saw. So in this case, I think the prosecutor does a pretty good job of laying out what her objection is.
Mr. Steele, you want to respond to that? Because that's critical to me. I mean, it's critical in the sense that if there was no conversation between the two of them, then that would assume facts not in evidence. Hold on. I'm asking Mr. Steele a question now. Just hold on, Ms. Love. Okay.
On the recording that you just heard at the beginning, the first couple of minutes, and I don't have the time in front of me, what's not shown on the screen, Mr. Bean said when he spoke with the detectives or the authorities, whatever his words are, at the hospital. That's what he says.
Okay, but here's her beef. If you'd have said, who'd you talk to? And he said, I talked to Detective. Well, was it Detective Lewis? Was it Detective Quinn? Was it Detective whoever? What I think that the question assumes is he did in fact talk to Detective Lewis, and he didn't.
I don't know if that's true.
Well,
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth.
Yeah, well,
That you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
But you all can't. But you two, neither one of you can proffer that.
Judge.
It's not proper, Mr. Steele.
No. Listen.
It's not. It would be a violation before me for you to put that in front of this jury.
You're not letting me finish. In the September 17, 2000.
You are saying to the court that you have a belief that there is another statement out there. There's not.
How could you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well, go ahead and make a statement and see what happens.
Your Honor. Listen.
Well, things are getting pretty spicy there, aren't they? This is the point in time where if you're smart, you say, Judge, I understand your ruling. I'm going to ask you to reconsider if we can provide you with the evidence that these statements were made. We have the transcript. We will go through it. And by the next break, we should be able to produce this evidence for you in what we have. And if the judge says, okay, that's fine, then you go on and you leave it alone until you can get to the point of redressing it later on. But what you don't do is stand there and continue to say, listen, Judge, because listen is disrespectful. It's, Your Honor, with all due respect, I don't believe you're hearing what I'm saying, or maybe I'm not being clear. You don't put the onus on the judge. If at all possible, you say, obviously, I'm not being clear with what I'm saying here, Your Honor. And you try to be as respectful of the judge as you can, but what you don't do is you make him issue a warning like the one he just issued there. Ask that question, you see what happens. I guarantee you what's going to happen. You're going to get cited for contempt. You're going to have to bring your checkbook and take care of the problem. This is not something you want to do. It doesn't benefit your client, and it doesn't benefit you in any way. All it does is it violates rule number 1, don't honk off the judge. There's a difference between being an advocate and being pig-headed. You don't want to be pig-headed. You just want to be a good advocate. In addition to that, the prosecution wanted to admit evidence of a conversation between detectives and one of the defendants. And the defense had interposed a motion to suppress that. And this is the way that conversation went with the judge.
I've had an opportunity to take a look at and consider the motion to suppress statements of defendant DeMontre Kendrick, and also to take a look at the state's response in respect to those particular assertions in terms of the for Jackson Daniel hearing. The court has to make those determinations of voluntariness thereof. What was the last thing you heard, Christina? The court has to take into account to determine the voluntariness of statement. In such, I have considered as well, and will be admitted for purposes of the motion to suppress, Jackson Dental hearing states 1 and 2, Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer I don't want to talk no more. And at the second video, starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling, okay?
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
You have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had a chance to take a look at Mr. Uhelski sent me as well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentencing. Mr. Kendrick appealed the severity of his sentence. So I'm taking a look at the appellate order, at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it during the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paul Doe and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I said.
Now I am going to spare you the next 10 minutes of this ridiculous argument, because for the next 10 minutes, this prosecutor says the same thing over and over and over again. And the judge says the same thing over and over and over again. Once a suspect has invoked their right to counsel, questioning must stop, and you don't get to trot them outside, give them a couple of smokes, buddy them up, and then get them to, quote unquote, reinitiate. Because they're not reinitiating, it is the detective reinitiating. So, and of course, they do that outside the area where there is recording and a transcript, so that they can bring in the officer and have him say, oh yes, I swear on a stack of Bibles that this guy reinitiated. And of course, that works a lot of times, and it especially works in federal court. but it shouldn't work ever. And this judge isn't having it. And I love this guy. So let's jump to the end of this ridiculous diatribe now.
Once you initiate your right, or you revoke your right to be examined and have counsel and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And at that, you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. So, and that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor,
If you've got if you have other evidence independent of this, I'll consider it at the appropriate time.
and we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309 Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306 Georgia at 35, Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available or until the suspect reinitiates the conversation.
Your Honor, at some point, Your Honor,
I'm talking,
Your
and
Honor,
I
at
don't
some
know why
point,
I am being interrupted. I will
rulings
not
need
stop.
to be final.
I was speaking.
Ms. Love, y'all got.
I'm sorry, I was
Both
speaking.
y'all can't talk at the same time.
I know, I was
Honor, the
speaking, and I
state
expect
talked
to
for
be
years.
allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein interrupted.
But you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
And I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're going to win some, you're going to lose some.
I do accept that
Okay,
fact.
no,
but
you
Judge,
don't. No, you don't.
Your Honor, we have just...
Look at that face. Look at that face. Does that not just make you smile? I mean, that's like when you were a kid and you pushed your dad just a little too far and he gave you that look and you knew, uh-oh, I've gone too far now. Like I said, I love this judge because he's made his ruling. The woman has continued to say the same thing over and over and over again for 10 minutes. And finally, the judge just has enough. Stop. Just stop. And, lawyers need to learn that lesson. I mean, I think it's hard for all of us because, we want to win. We're fighting for our client. In this case, the state. The state is fighting for the people of Georgia. They want to win. But you have to respect the judge and his role. And sometimes that means you have to sit down and shut up. So that's what I have for you today. Thank you so much for being here and watching. And I especially want to thank all of my new subscribers. You guys are great. I appreciate all of the comments. If you have any comments, leave them in the comments down below, or you can email me at the address above. Like, share, subscribe, all that stuff we ask you to do. And of course, if you have the opportunity today, do something nice, maybe for a coworker, maybe for a neighbor. A couple of days ago, my neighbor pulled my trash can around for me after I had to run out in the middle of the day. Pulled it around after the trash truck run so I wouldn't run into any trouble with the Homeowners Association, otherwise known as the Neighborhood Nazis. Anyway, it is nice when people do nice things for you, so you always should do nice things for other people because kindness is never repaid. It's only passed on. So pass some along today, and then come back here tomorrow and catch me at the beach. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.